The next case to come before us this morning is Avon Lake Board of Municipal Utilities, Avon Lake Regional Water versus Kopf Construction Company. Both sides will have 15 minutes to present oral argument. It's my understanding that the attorneys have had discussion with our bailiff regarding the fact there's a cross appeal, but they have been combined. So the appellant will have 15 minutes to present oral argument on both, but can reserve up to 5 minutes for rebuttal. The appellee, the original appellee, will have 15 minutes to present oral argument and must utilize that 15 minutes while they are at the podium. So we are hearing, each side has 15 minutes, but the original appellant will have that 5 minutes of rebuttal.
And so we will not have the rebuttal time, is that correct?
Correct. They will not have more than 15 minutes, however.
Understood.
Okay. And they don't have to reserve, it's optional whether you want to reserve any time for rebuttal.
Thank you, Your Honor.
Certainly. We are, as you know from the previous case, we are recording these proceedings today, and the recording will be placed on the board's YouTube channel. You will note that you see two judges sitting up here today. There are 3 judges hearing this case. One of our judges could not be here today. That judge will review the oral arguments, and we will conference at a later time. But it's especially important that you keep your voice up and remain behind the podium. And also, we always make this admonishment, don't use the names of any victims or minors for that same reason. I don't think that's at all relevant to this case, but we always make an advisement before individuals get started. We've read the briefs, so we're ready to proceed when you are.
Thank you, Your Honor.
Would you like to reserve any time for rebuttal?
I would like to reserve 5 minutes, please.
Certainly.
Thank you. May it please the court, my name is Brian Borla. Along with co-counsel Ken Rezar, we have the privilege of representing the appellant and cross-appellee Kopf Construction in this appeal. Kopf Construction is requesting that the court reverse the trial court's grant of summary judgment to Avon Lake. At issue is the court's application of a tap-in fee, or a TSSF fee, that Avon Lake has charged against Kopf Construction for the construction of apartments on a prior aquamarine resort parcel. With the limited time, I'd like to address and highlight 3 issues for the court. Before I do, I'd like to discuss the central ordinance, the central piece of legislation in this case, that all agree, and the trial court agreed, is the central piece of litigation. And it is Ordinance 5384 that was passed by Avon Lake City Council. That ordinance is not ambiguous. It required, among other things, that the board adopt a policy to enforce the ordinance. The express purpose of the ordinance was for the construction of 6 sanitary trunk lines identified on 6 specific roads. The ordinance stated, all fees paid shall only be used for construction of the 6 sanitary trunk lines. The ordinance further went on and said that existing improved property at the time of the ordinance would not be subject to a tap-in fee, and that unimproved land at the time upon development would have to pay a tap-in fee. The ordinance was adopted wholesale by the Avon Lake Water Department and its regulations in 1985. And those regulations remained unchanged until 2017, after this dispute became apparent, when Avon Lake decided to add some context and definitions of improved and unimproved, where they changed their regulations to then indicate that a fee would have to be charged on improved land, like a golf course, where there was a change in use that would generate wastewater. That was not in the original ordinance, that was not part of any regulation at the time of this dispute. And so the question before the trial court, in essence, was whether or not Avon Lake had the authority and right to charge tap-in fees for dwelling units, apartments, that were previously constructed on a golf course. And so the first issue that I'd like to talk about is this question about improved versus unimproved property. And we believe that the court erred in accepting the Avon Lake's definition of improved and unimproved, because we believe that that term is unambiguous.
What about the statutory right to define those?
So in Norton versus Adair, the 9th District spoke of that and said the district's right, or the governmental right, applies to constitutionality issues, but as it pertains to implicit definitions, a trial court must first determine that the term is ambiguous before it starts going out and accepting other definitions. And so in Adair versus Norton, the court said the trial court failed to make that determination and remanded it back. In this case, there was undisputed evidence that the property at issue prior to the development of the apartments was an 18-hole golf course, irrigation system, storm drainage system, rain shelters, clubhouse, maintenance building. Yet in the court's decision, it refers to the only contrary evidence as the course had an irrigation system. But the testimony was in front of the court on that issue. John Knipper, who was the chief utility executive at the time the ordinance was passed and was the chief utility executive who evaluated how the cost of the tap-in would be calculated, he provided testimony that it was his opinion, albeit the board had ultimate final authority, but that it was his opinion when he did that calculation that the golf course was not unimproved property. He excluded that from his calculation. And Avon Lake takes issue with any reliance on Mr. Knipper's testimony, saying, hey, look, it is the board's decision. Yet, on page 5 of their brief, they state the board, through its chief executive, in this case Mr. Monroe, has exercised reasonable discretion in distinguishing properties as far as what's improved and unimproved. And so the court summarily rejected Mr. Knipper's testimony and the evidence that we had presented about how the property had been improved. Importantly, when Mr. Monroe's deposition was taken, and their position that the property was not improved, he first admitted that he didn't know what amenities were on this golf course when he made his determination. And then finally, he admits that when he was told about the golf course and all of the amenities, he says, yeah, it's somewhat improved.
Well, there's an improved portion, though, is what the result was.
Well, so the result, well, we were talking about two different properties. There was a resort with a 250-room property or building on it. That is not an issue. They had already determined that that was improved. What was at issue was the acreage for this 18-hole golf course. And when Mr. Monroe was presented with all that went in, as I outlined here for the court, he said, yeah, I agree, it is somewhat improved. And even...
So your position is that the word unimproved or improved is not ambiguous?
It is not ambiguous.
And so your definition would be?
My definition would be, as Webster's talks about it, to enhance in value, quality, or to make better. Black's Law defines it as land that has been developed. The 9th District, in an older decision, considered a parcel of land that only had a retaining wall on it as improved. The Supreme Court has referred to a golf course as improved property. That's in Atwell versus Board of Park Commissioners. And so the court made two errors. First, it didn't make any determination whether or not improved or unimproved was ambiguous. And even Avon Lake, in their briefs, acknowledged that under the common definition of improved, the golf course fits that definition. And so the trial court erred in first, not making a determination as to whether the term was ambiguous or unambiguous before it then went into the analysis of accepting Avon's definition. And interestingly, Avon's definition has kind of changed throughout the case. Mr. Monroe says that improved means that the property does not need potable running water and or wastewater services. But on page 3 of their brief, Avon Lake claims that it's unimproved because it didn't have buildings. So even Avon Lake can't seem to get that definition correct. And it is why they changed their regulations. They passed a resolution to clarify this issue in 2017. And so the courts arbitrarily accepting Avon Lake's definition of improved versus unimproved was error. And frankly, if this court determines that the word is not ambiguous and that the dictionary or commonly accepted term means land that's been developed or enhanced in quality or to make it better, the case is over.
Should we be determining whether it's ambiguous in the context of a sewer system, though?
I think this court can make the determination as to what improved land means, because that's the question. Because at the time of the ordinance, they were evaluating improved land, not for purposes of sewer. There was no evaluation as to whether there were sewers or no sewers. It was, let's look at all of the remaining unimproved land in the city of Avon and divide and assume 2.1 units per acre and divide that cost amongst all of the unimproved land. And so the question really is a golf course property with 18 holes, irrigation, storm sewers, rain shelters, clubhouse, is that improved property? We believe it is. And as such, it would not then be subject to the TSSF fee.
And Council, you're just now reaching that 5 minutes of time. You may continue or reserve as you see fit.
Thank you. Let me just comment on one other piece. First, we think the court erroneously applied this ordinance because it is specific. The ordinance is unambiguous. It says it shall be used for the construction of the 6 sewer lines, not maintenance, not anything else. And in fact, there was evidence before the trial court that the prior owner of the golf course property had already paid an assessment for the sewers that it utilized on its property. Because importantly, the 6 sewers that are identified in the ordinance, none of them serve this property. And so, looking at the language of the ordinance, that the term shall only be used for construction of the trunk sanitary sewers is important. And Avon Lake's reliance on Amherst, USA Management, and Huber are misplaced because the ordinances in those cases applied to the sewer district. That's not the case here. They don't have the founding ordinance to allow this. Had they created a regulation, which they're permitted to, had they created a regulation or a resolution that all residents or all property in the Avon Lake City Sewer District has to pay a tap-in fee, we'd have a different issue. But the authorizing ordinance doesn't give it to them. Finally, one other issue I just want to comment on is the statute of limitations. And I think the trial court just missed this one, frankly. Even if you accept the trial court's 6-year statute of limitations, evidence that Avon Lake presented demonstrated that there were units outside the 6-year statute of limitations. The letter says, we became aware of units that were constructed in 2012. They filed suit in 2020, March 10th, 2020. So any claims prior to March of 2014 are barred, and they acknowledged there were units in 2012, 2013, 2014. That was uncontroverted evidence that there are units that are beyond the statute of limitations. With that, I will pause. Thank you.
Thank you, Council. You have approximately 2.5 minutes for rebuttal.
Thank you, that's what I showed. Thank you.
Corp, we just, 2 seconds.
Council, I don't want to block the view of your table. However, if you don't move that closer to the podium, it will not be on the video.
Oh, very well, I'm sorry.
So I think
Yeah, go ahead.
make whichever choice. Thank you.
May it please the court, my name is Bruce Rinker, and I'm here on behalf of Avon Lake Regional Water. And if I may, I'd like the court to bear with me because listening to the arguments that have been reiterated by Kopf Construction, I think underscores the value of the 2 exhibits that I positioned in front of the court. Bear in mind, we're looking at summary judgment, and insofar as the court is called upon to consider de novo the issues raised in summary judgment, we think that this will be a useful document.
And that was a trial court exhibit, Council?
Yes, it was.
Okay, just double check.
Absolutely. And it's been authenticated both by Mr. Knipper at his deposition and subsequently by Mr. Monroe. And this was admitted into evidence. And I think appellant actually submitted Mr. Knipper's deposition into the record as well. We absolutely disagree that whether improved or unimproved may be unambiguous in Webster's dictionary. The enabling legislation, Ordinance 8453, made it abundantly clear that ALRW had sole discretion to determine what was going to be improved or unimproved. And this wasn't something that was subject to change. From day one, the TSSF, this tap-in fee, was administered consistently. In fact, what the board chose to do was every year was add a cost of living factor. There's an index, Cleveland Construction Index, and dutifully, every single year, the board added that. So it happened over time, kind of like Social Security, it was adjusted for inflation. But in effect, a person who tapped into the system in 1984 up to the present day pays the same tap-in fee. And we do agree that Amherst, which was a decision that this court affirmed by the Supreme Court, indicates that sewer districts do have that ability to be able to charge a tap-in fee. The Huber case even says whether or not you're even connected to the particular project. It's not looking at a project-specific scope, it's looking at the entire system. ALRW is a charter entity. It actually predates the charter adopted by the City of Avon Lake in the 50s. It's a very unusual setup here. There's the Avon Lake City Council with the mayor and its building department, other departments that all answer to the mayor. Then there's a separate elected body, ALRW board. So the residents vote these board members in. And under the charter, I think it's charter section chapter 51, the charter expressly gives this board the authority as a statutory utility. So there's no question that it has the authority under the Constitution, under state statute, under the city's charter. That's the enabling legislation that authorizes a board of utilities to provide sewer and water. These are public health and safety benefits that are provided by a public agency for the public benefit. The tap-in fee has consistently been held by our courts as long as it's reasonable and fair that it can be upheld. And in this case, even though there was an original estimate of the construction, this wasn't a special assessment. For example, if a subdivision has homes on septic and you've got to go into a sewer system, you typically put the project number up there and divide it by the number of units that are being benefited. A tap-in fee deals with anybody who benefits from the system. So what I want to point out is Mr. Kopf himself made a point of saying that for more than 50 years, as the president of Kopf Construction Corporation and as owner, member, controlling shareholder, and officer of numerous other business entities, I have been actively involved in the development of large portions of the real property located in the city of Avon Lake. So what you have in front of you is a map that Mr. Monroe was able to unearth around the time of Mr. Knipper's deposition, of a map that was prepared by the Utilities Department when Mr. Knipper was the CUE. It identifies properties in Avon Lake as they're characterized 6 categories of vacant land. The white is the improved land. So at the time, contemporaneous with the adoption of the ordinance, this map reflects how the Board of Utilities was going to look at what properties were improved, what properties were unimproved. Pay special attention to the 2 yellow shapes that are on there. The smaller one that's kind of has a dividing line through it, that shows the aquamarine resort area in white and the golf course in yellow. It's identified as recreational land, one of the 6 vacant land categories that the city and the Board of Utilities apply. The larger square, farther to the southeast, is 2 old golf courses at the time of the adoption of the ordinance, Sweetbriar and Legacy. And guess who developed those? Kopf Construction. They dwarf in size the golf course acreage that was developed by Kopf for aquamarine. Now the way typically this works is, as the ordinance requires, you have to pay your fee prior to occupancy permit. What the record demonstrates, and we felt that the judge failed to look at closely enough, was that yellow big box of Sweetbriar and Legacy. All of those properties were built, dwelling units, single-family homes, by Kopf around the same time that aquamarine was being developed. They had the same improvements of a sprinkler system, rain shelters, tee boxes, all the amenities that go with the golf course. But they had been characterized as unimproved. And guess what? The record shows that Kopf Construction paid every single one of the hundreds of connection fees required for Legacy and Sweetbriar. So what distinguishes those acres from aquamarine? Physically, functionally, absolutely nothing, which is why the board concluded that everything on the aquamarine golf course is treated as unimproved. The difference, though, is that on aquamarine, at the time that construction began in 2006, Kopf paid the TSSF for the number of units that were phase 1 built on the golf course. Didn't object to it. And in fact, at the same time, the board credited or exempted a number of units that were concurrently built on the resort acreage, which is consistent with the ordinance, consistent with the application from day 1. Kopf never objected. 6 years go by and there's no construction. And then work resumes. But we don't find out until about 4 years later. And it seems prosaic, but the distinction between the other 2 golf courses and this one, all those other units have individual meters. The water bill goes to the individual owner. The board is able to track those. But the occupancy permits aren't issued by the board. They're issued by the city's building department. And unfortunately, there was a right-hand, left-hand disconnect, a bureaucratic problem between a building department that issued permits and the Board of Utilities that provided the services.
So that gets you into the statute of limitations issue. Do you have an argument with regard to the statute of limitations, the 6 versus the 4, and
Correct.
the ones that were completed after the 6 that we're talking about here today?
Well, the discovery rule does not apply in this instance. That's a position that we have argued. Now, Judge Raleigh indicated, he implied that this was a statutorily authorized fee to charge, and applied a 6-year statute of limitations there.
But what about,
This court-
what about
go
the
ahead.
argument that it's, like you're providing a utility and it's more contractual?
But it goes beyond contractual. Remember, this is a public service and a benefit is provided. The whole idea of a tap-in fee is that the public, so you don't balkanize and tie into individual special assessments. You need some mechanism to be able to construct and maintain and regenerate. They've taken the position that somehow this was a special assessment, it's a one-time payment, and then you're done. That's never been the application here. So what happens is that people get the benefit, and Kopf benefited from having a single master meter connection to the water system for Aquamarine. Translation, these other golf courses, there are hundreds of individual fees and bills that are paid because those are meters. Every single one of those has a meter. Here there's one. Kopf had an opportunity, saw an opportunity and took it, which is being able to hook up to a master meter. The water bill comes in, and I think over time you can see the flow is higher. But the occupancy permits are issued by the left hand, not the right hand that's monitoring this. So you have someone who's benefiting from sewer and water being provided on the public fisc, supported by other users. Kopf is able not to have to pay that money. And if we think in terms of, say, paying taxes, this is somebody who's able to bank money that's not paid for the fees. If this argument were so compelling about what's improved or unimproved, why was Kopf not making that argument for Sweetbriar and Legacy? Why not? They couldn't argue because every single residence is metered. This one, there was an opportunity to hook up and nobody would be the wiser, at least not initially. That's unjust enrichment. And this court has held, and it's looked to other districts as well, the Desai versus Franklin case, and it looked at Palm Beach versus Dun and Bradstreet, which says you start the clock ticking for statute of limitations when the last benefit is conferred and it hasn't been paid for. That exists today. Arguably, the statute of limitations is not run because Aquamarine properties that Kopf has insisted it doesn't have to pay have benefited for free. That's not right. And that's why we have argued, and we felt that the trial court erred in not looking, taking a more clear-eyed look and realizing that this sophisticated corporation, having developed most, if not all, of Avon Lake, conveniently argues, oh, we don't have to pay this over here, and challenges the authority of the board with this argument, but concurrently doesn't do it the other. That just doesn't wash. This wasn't a simple dispute that had to be litigated. This was a conscious, concerted, calculated decision by a business enterprise to take advantage and basically cut a profit by benefiting for free from public services that were provided. And that's the gist of this argument. This is a constitutional, statutory, charter power. The ordinance gives the board the full discretion. The board consistently and fairly has administered it. The record shows that. And the record also shows that Kopf's argument is disingenuous at best. And if nothing else, we think it's appropriate for this court to rule, since all of the connections have been made, that's unrefuted evidence, Kopf has to pay for all of these connections on Aquamarine, not just the first two chunks that the trial court determined. But we also think it's appropriate for having to fight this fight on behalf of the public at public expense, that the matter be returned to the trial court for the determination of reasonable attorney's fees and other exemplary damages which were pled from day one. Thank you, Your Honors, we appreciate that.
Thank you, counsel.
Thank you, Mr. Rinker. A couple things, Your Honor, I'd like to address, and I know I have a little itty bit of time on it. First off, there was no testimony about when this map was created, only that it was found in a box sometime by Mr. Monroe as this case was proceeding. Mr. Rinker talks about the enabling ordinance and Article 4 of the Constitution. Indeed, Avon Lake has the right to create ordinances, but it speaks through its regulations. It speaks through its ordinances. And what is noticeably absent from this case are any of those things until 2017. And we discussed that. We discussed that in our brief. Mr. Rinker talks about legacy and Sweetbriar. One of the distinguishing differences, those properties are on the trunk lines identified in the ordinance. That's a material difference. We talk about, in an effort to avoid the statute of limitations, he talks about a unjust enrichment. But even in their brief, they acknowledge it's a one-time fee. Usage fees are being paid. Those are continuing to be paid. This is a one-time fee. And Desai and Palm Beach are different. And the facts of those cases are different. In Desai was an employment arrangement in which the plaintiff was claiming he was not being paid continuously for each week, bi-week, month, year of work. So it was a continuous withholding, event after event. You didn't pay me enough this time. You didn't pay me enough this time. Palm Beach was the same thing. There was evidence of continuous multiple withholdings, multiple events. In this case, Avon Lake has pled in their brief, it is a one-time fee. Unjust enrichment policies don't apply, and I appreciate their acknowledgement that the discovery rule doesn't apply either. But they certainly had time to file in 2016 and 2017 that would have picked up all of these cases.
Counsel, you have about 5 seconds.
Yeah, thank you. The trial court addressed sanctions and attorney's fees and said it was without merit. There's no reason to overturn the court's decision on this. Kopf acted in good faith based on the clear and unambiguous language of the statute. Thank you. It's been a pleasure to be here today.
Thank you. Thank you both for your presentations today. The court will take the matter under advisement. We will issue a written decision which will be mailed to all parties to this appeal, as well as posted on the Ohio Supreme Court when it's issued. Thank you, everyone.
Thank you, Your
Enjoy
Honor.
the
Thank you,
stay.
Your Honor.